In this section, we're going to cover third parties, discharge, and remedies in a contract. So the third parties that could be benefited from a contract are an intended beneficiary or an incidental beneficiary. So when we talk about these third parties, they're not actually part of the contract, meaning they're not in privity of contract. They're not named in the contract, but they might still benefit from the contract. An intended beneficiary is one whom the contract is made in favor of. So this person was thought of by the parties when the contract was made, and they're going to be benefited by the contract. An intended beneficiary can often sue for enforcement of a contract, even though they're not actually part of the contract. One person who is an intended beneficiary is a creditor beneficiary. This is an outside third party to whom one or both of the contracting parties owe a continuing debt or obligation arising from the contract. There's also a donee beneficiary, which is a third party who provides no consideration for the benefits received under the contract, but the contracting party still owes the act promised. And then there's an insurance beneficiary. And this is usually a beneficiary on an insurance policy. They can sue for enforcement. This might be a life insurance beneficiary if my husband passed away and our children were the beneficiaries under his policy. Even though they weren't part of the contract, they could still sue for enforcement of that contract. Incidental beneficiaries are people who might benefit from the contract, but they weren't intended beneficiaries and they have no rights to sue under the contract. All right, so here's an example of a creditor beneficiary. Suppose a debtor owed a creditor $500. The debtor lends $500 to a third person who promises to use the money to pay the debtor's debt. The third person is the promisor who makes the promise to be enforced. The debtor is the promisee to whom the promise is made. The contract between the debtor and the third person, the promisor, and the consideration for the promise is the $500 loan that the promisor received from the debtor. The creditor is the third-party beneficiary. If the promisor refuses to pay the creditor, then the creditor may sue the promisor and prevail. Although the creditor is not a party to the contract, the debtor and the promisor intend that the creditor should be the beneficiary of the contract and therefore has enforceable rights. The debtor or creditor may sue to enforce the promisor's promise to pay. The creditor's right to enforce on the contract between the debtor and the promisor is effective only when he or she learns of and assents to the contract. Creditor may also sue the debtor for the $500, as the debtor had a legal duty to pay this loan. The debtor then may sue the promisor for breach of contract for refusing to pay the creditor. And here's an example of a donee beneficiary. A donor wishes to give a donee $200 as an anniversary present. The donor plans to sell a TV set for $200 to a purchaser who promises to pay the donee the $200 directly. The donee is a donee beneficiary of the purchaser's promise to pay the money and may therefore enforce this claim against the purchaser. The donee has no claim against the donor, the promisee, as the donor has no legal duty to the donee, but is merely giving the donee a gift. However, the donor will be able to sue the purchaser for refusal to pay the donee because it would be a breach of the terms of their contract of sale. Contracts can also generally be assigned, this generally is a right of all contracts unless it's forbidden by either the writing of the contract or the type of contract it is, and we'll talk about that in a later slide. But an assignment is the transfer of contract rights, and a delegation is a transfer of contract duties. In an assignment, an assignor is the person who assigns the right or delegates the duty. An assignee is the outside third party to whom the assignment is made. And the obligor is the remaining party to the contract that hasn't changed. Like I said, assignments and delegations are generally permissible and no additional consideration is required. But if there is no additional consideration, the assignor may repudiate the assignment if there's no consideration given. And creditors may also rescind an assignment if it's a fraudulent conveyance. And this happens a lot in bankruptcy cases. So a debtor in bankruptcy may have money coming to them, say from a service they performed, and instead of getting the money paid to them, they assign the payment of money to someone else so that money isn't in their bankruptcy estate, and then later that person gives them money back. So in that case, a creditor has a right to rescind that assignment. Assignments must conform to the equal dignities rule, which requires the assignment to take the same form as an original contract. So if the original contract was made in writing, the assignment must also be made in writing. Otherwise, assignments can be made orally or any other way. An assignment is considered valid when made, but the assignee should give notice to the obligor, that the obligor should direct payment or benefits to the assignee instead of the assignor. The obligor, however, does get time to verify that it's a valid assignment. There's also what we call a novation in assignment. So in a traditional assignment, when a party assigns all rights and delegates all duties to a third party, the assignee works directly with the obligor, but the assignor is still in privity of contract. So there's now 3 people, essentially, that are part of this agreement. So the assignor is still in privity of contract and then is still liable to the obligor if the assignee does not perform. But if a novation is agreed on by all 3 parties, then the assignor is substituted by the assignee in the original agreement. So then the assignor is not liable on the original agreement. The assignee steps into the shoes of the assignor, which means that the assignee has all the rights and duties. They have the right to sue, the duty to perform that the assignor had. And any warranties and anything that the assignor was obligated to provide, the assignee is now obligated to provide. The obligor is allowed a reasonable time to verify a valid assignment. The assignor is going to imply that the obligor will respect the assignment. So when the assignor assigns something to the assignee is warranting that the obligor will pay or provide benefits to the assignee. And the assignor warrants that any duties delegated to the assignee will be carried out in a complete and satisfactory manner. There are certain restrictions on the ability to assign, which I briefly touched on. One restriction is personal and professional service contracts. So if it is a generic contract, it can be assigned. But a personal contract is a contract that's other than routine, and the party to the contract was selected because of special abilities or talents. This might be a doctor, a lawyer, another type of profession. It might be an artist. It might be a musician. Somebody who is selected because of their abilities and talents. That cannot be assigned. If there are restrictions imposed by the original contract that say the contract is not assignable, then you cannot assign it. And if there are restrictions imposed by law, you can't assign it. One of those might be that it's contrary to public policy. So service members or police officers cannot assign their duties or their pay because that would be contrary to public policy. A contract is generally discharged when all parties perform. That's why we enter into contracts, to have both or all parties to the contract perform as said in the contract. So when we talk about performance, the time for performance, if not specified in the contract, is just a reasonable time. And that would be a question of fact for the jury if it ever were tried. If the time is stated in the contract, but the time is not stated to be of the essence, the time will usually be extended by the court. Performance can be satisfactory performance, which is a standard based on someone's personal taste or objective standard that's determined that the contracting parties have performed their contractual duties according to the agreement. If that is met, if satisfactory performance is met, the contract is discharged. It can be complete performance, where all parties fully accomplish every term, condition, and promise, and that obviously discharges the contract. And then there could be substantial performance under the contract, where each party in good faith executes all promised terms and conditions with the exception of minor details that don't really affect the real intent of the agreement. And that will often discharge the contract. Most of the time it will. The exception would be if the party who accepts this performance complains and says, well, you didn't exactly perform it like it says in the contract. So that would not then discharge all the obligations of the contract. There can be conditions of performance, and we have discussed these before, so I'm just going to read them, and you can go back to the previous slides that really explain them and show examples. But Conditions of performance are condition precedent, condition concurrent, and condition subsequent. So a condition precedent is an act or promise that must be performed before the other party is obligated to pay or perform. A condition concurrent requires both parties to perform at the same time, and a condition subsequent requires that parties agree that the contract will be terminated when a prescribed event occurs or fails to occur, maybe a passage of time or something. Tender of performance is important. Tender of performance is an offer of performance under the terms of the contract. And even if you are part of a contract and you know the other party is going to breach and is not going to perform, you still have to tender performance in order to be able to sue on the contract and not be in breach. So a non-breaching party must offer tender of performance even though he or she knows the other party isn't going to perform in order to be able to sue on the contract and not be held in breach. The contract can also be discharged by non-performance. So non-performance is failing to fulfill or accomplish a promise, contract, or obligation according to its terms. All right, so you could have a discharge by agreement, and that would be a termination by the terms. So terms may indicate when the contract terminates. It could be a mutual rescission, so both parties could agree to rescind the contract. It could be a termination by waiver. So if the contract has not been performed satisfactorily and one party has the right to complain but does not complain, that contract has been terminated by waiver. It could be terminated by novation. Remember, we talked about that just on a previous slide in this section, how all three parties agree to substitute one party for the other. It could terminate by accord and satisfaction, and we have talked about this before, where we accept something different than what the contract calls for as full performance of the contract. And it can also be terminated by general release. And that's usually when a creditor releases a debtor from obligations on a valid debt. It could also be discharged by impossibility in operation of law. So impossibility is some situation or circumstance that arises after the signing of the contract. Maybe I was going to buy a house and the house catches on fire and burns to the ground. The contract is discharged, and it's discharged by impossibility because I can no longer perform on that contract. It might also be discharged by operation of law. If I entered into a contract to do something and then before the contract was satisfied, that thing we were going to do became illegal, then that contract would be discharged by operation of the law. Finally, it could be discharged by a breach. And the breach could be deliberate. A party just does not perform. It could be an anticipatory breach, and that's when a party knows they aren't going to perform, they notify the other party that they aren't going to perform, and they try to work out an acceptable settlement for that. And then there could be a discharge by breach by abandonment, when a party begins performance but then stops. So they stop once performance has begun. When a contract is breached, usually the non-breaching party receives some sort of remedy, damages or equitable remedies. Most of the time, courts prefer to award damages in contract cases rather than equitable remedies, and damages are money awards. So money awards can be calculated in different ways. The first is actual or compensatory damages. This is an actual loss suffered by the non-breaching party. So it's easily measurable, right? I was going to do this. I didn't get to do this because you reached the agreement. It cost me $2,000. That's my actual damages. Other damages could be incidental and consequential. So incidental are losses indirectly but closely attributable to the breach, maybe money paid to prevent further loss. And consequential damages are foreseeable damages that result indirectly from the breach because of special circumstances with a particular contract. So let's look at these two examples. The first is incidental, the second is consequential. In the first, Bright Light Bulb Store contracts to install 100 light fixtures in a local mall within 7 days, and so enters into a purchase agreement with a supplier to buy the fixtures. The supplier agrees to deliver the fixtures within 3 days. On the 5th day, the supplier notifies Bright Light they cannot fill the order, breaching the contract. Because the mall is unable to change their timeline, Bright Light loses the contract and has to refund the mall's money. The losses incurred by bright light are a direct result of the supplier's breach of contract and so are considered incidental. Now, continuing on, the mall in the above example fails to make their deadline to open a new store because installation of the lights is delayed and they lose 2 days rental income as a result. The mall's losses are caused by the result of the lighting supplier's breach of contract with bright light, and these are consequential damages. So these are foreseeable and they result indirectly from non-performance of the contract. There can also be punitive damages. Punitive means punishment. So these are in excess of actual losses. They're awarded usually when a defendant is abusive or dishonest and conduct is unconscionable and contrary to public policy. So this happens often in a case of fraudulent misrepresentation. We do not represent adequately what we are actually contracting to. Another type of damages are nominal damages. A party might get these when they don't actually suffer a financial loss, but they did lose a legal right. Parties may get present and future damages, and parties may get liquidated damages, and that's when the parties agree to a certain amount of damages in the contract if the contract isn't performed. These are awarded and respected by the court unless they're excessive. Courts might also find damages using quantum meruit, and this arises when one party's been unjustly rewarded, but there was no contract. There was no express or implied agreement between the parties. So there was never a contract to breach, but one party was unjustly rewarded. In that case, courts may award damages in an amount reasonable in return for the benefits one party received from that quasi-contractual relationship. There could be speculative damages. There could not be speculative damages. Courts do not allow speculative damages. Speculative damages are losses that haven't happened and can't be proven. And finally, parties are required to mitigate damages. And that means when a breach happens, the non-breaching party must do everything in its power to stop the losses. So in a landlord-tenant case, for example, if I own a property and I have a tenant in there and the tenant breaks their lease and they stop paying, I have a right to damages from that tenant, but I have to also continue looking for a new tenant during that time and mitigate the damages. I can't just leave that home open and unrented and just keep collecting from that person without trying to mitigate the damages. In breach of contract cases, you won't have every type of these damages. These are all different ways that a court may calculate damages, but you would not have all of those types. There's also equitable remedies, and like I mentioned before, courts prefer not to use equitable remedies. They prefer to use damages when a contract is breached, but sometimes damages won't work. They're not satisfactory, and so they have to use equitable remedies. An equitable remedy is an order to perform an act or refrain from performance of an act. So in a contract case, a court could order specific performance. This is disfavored by the law. Subject must be unique or rare. Specific performance requires the parties to perform under the contract. So it actually requires the parties to do what the contract said to do rather than just money damages. If I'm under contract to buy a unique piece of art, say I want to buy a Monet, and there's, we're not making any more, right? And it's this specific Monet I want. A court, and I've entered into contract, and I have tendered performance, and the other party has breached. They have not delivered the painting. Well, the court might award specific performance and might require the party to turn the Monet over to me. Another type of equitable remedy is an injunction, injunctive relief, and it's an order for a party to refrain from an act, either temporarily or permanent. A temporary injunction is a pretty common equitable remedy, so courts can sort out what the rights and duties and remedies of each party is. A permanent injunction is less common, but it does still happen. So a party permanently cannot do an act because of this injunction.